I want to begin by thanking you and your staff for all your hard work. Our conversations on this bill began months ago, before this legislation was ever introduced, and continued until late last night. And I appreciate your professionalism, your compassion with the King family, and your willingness to work with us. AB 1844, Chelsea's Law, is named in the memory of Chelsea King. On Thursday, February 25th of this year, Chelsea King went missing while on a run in a San Diego park. She was a lively, articulate, and passionate 17-year-old who was finishing her senior year in high school. This Thursday would have been her 18th birthday. Law enforcement and an entire community searched for days. What happened is every parent's worst nightmare. Your child is missing, and you imagine the unthinkable. Chelsea was found just a few days later, the victim of a terrible crime. A convicted sex offender who in 2000 violently molested a 13-year-old girl has pled guilty and been sentenced for the rape and murder of Chelsea King and Amber Dubois, a San Diego 14-year-old who had been missing for more than a year. He's also pled guilty in the attack on another young girl. This tragedy exposed serious flaws in how California deals with violent sex offenders, and I think we all felt an obligation to take action and try and reform a broken system. Chelsea's Law is an attempt to try and isolate this uniquely dangerous predator and take significant steps to reform our system and protect our children. We are seeking to do this by a true life penalty without the possibility of parole for the worst offenders, by increased sentences for forcible sex crimes, by increased parole terms for those who target children under the age of 14, with restrictions on sex offenders' ability to enter parks while on parole, and with changes worked out with the committee, we'll be adding a key component to any comprehensive change, a containment model and dynamic risk assessment. And we are striving to do all of this with offsets to ensure we don't further complicate an overcrowded prison system or exacerbate California's ongoing budget deficits. The development of this legislation has been a collaborative effort with a wide variety of stakeholders: district attorneys, law enforcement experts, legislators, members of the Sex Offender Management Board, many people who have worked on public safety measures for many, many years. And I want to thank those that have provided so much assistance in our effort. In particular, I want to thank San Diego County Sheriff Bill Gore and District Attorney Bonnie Dumanis for their efforts. We're joined in support by DAs from around California, the California Attorney General, both of California's United States Senators, the Speaker of the Assembly, the Governor, the Superintendent of Public Instruction, law enforcement groups, and tens of thousands of individual Californians who've signed petitions, made phone calls, and been with us every step of the way. In addition to consulting these experts, we examined efforts of other states. We reviewed current statute and studies and have worked hard to produce a bill that focuses our efforts on the most dangerous. It is a complicated and broad bill, and I appreciate your chair, Mr. Chairman, and members, your patience as we walk through the various provisions and changes that have been made. The sentencing portion of our bill remains virtually the same as the version that passed the Assembly. It includes a true life without the possibility of parole for the worst offenders. One of the guiding principles of Chelsea's Law has been the belief that the worst offenders, those that violently assault children in a sexual manner, cannot be rehabilitated. Our bill institutes a true one strike, a life without the possibility of parole for a combination of forcible sex crimes with violent aggravating factors. This is significant because in the entire California Penal Code, there exists only one charge that yields a true life sentence. We made one minor change to this section. Those convicted of non-forcible lewd conduct with bodily harm will now face a sentence of 7 years to life with an indeterminate sentence. This life without parole charge is one of the cornerstones of Chelsea's Law and a major change to current sentencing. Chelsea's Law also seeks to increase penalties for forcible sex crimes against children. In current law, there's no distinction in the length of sentence between a non-forcible sex crime and a forcible sex crime. Our bill will increase penalties for 17 separate offenses. Each offense has a low, medium, and high sentence, so our bill will increase penalties in 51 separate instances. We believe this change will give district attorneys more options and help ensure justice for victims. In this area, we made some changes to the length of sentences in an effort to smooth them and have them follow a consistent pattern. Some were increased slightly, some were decreased slightly from the version that passed the Assembly. But the basic goal of longer prison terms for forcible sex crimes against children remains fully intact. The next piece of Chelsea's law relates to parole reform. AB 1844 provides for lifetime parole for sex offenses against children under the age of 14. While all sex crimes are awful, these crimes against such young children are a red flag that the perpetrator is capable of much worse. Our system should acknowledge this. In this area, we made some minor changes to various sections, but stuck with lifetime parole for the worst offenders and significant increases for all others. We've left lifetime parole for those offenders convicted under 4 separate penal code sections, the current indeterminate sentences for sex offenders. We've lowered the threshold for non-forcible sex crimes, 288A, to 10 years on parole. This is consistent with previous legislation this body passed that was inadvertently chaptered out by an initiative. And we've set parole at 20 years for offenders between non-forcible crimes, 288A, and those sentenced to an indeterminate crime. This encompasses 9 separate penal code sections. These offenders will be subject to a board of parole hearing that will have the ability to retain them on parole indefinitely if they are judged to be a continued risk. These extended parole periods for the worst offenders will ensure rigorous and active GPS monitoring of all. To summarize our parole piece, the worst offenders will remain on lifetime parole. Another group will be on for 20 years with the parole board option to retain them indefinitely, and low-level offenders will be raised to 10-year parole sentences. We think the focus on sex crimes against children under the age of 14 identifies the very worst and highest risk offenders who might not qualify for the life without parole sentence, which should be monitored. The final piece of our law relates to parks. Current law provides that sex offenders cannot live within 2,000 feet of a park where children congregate. However, nothing in the law says the same offenders cannot sit in a park all day long. That doesn't make sense. In this area, we've made a fairly substantial change. In the place of instituting a statewide exclusionary zone for all sex offenders, we've listened to the recommendations of the Sex Offender Management Board. Our bill will create a statutory parole requirement that all sex offenders on our enhanced parole of 20 years or greater may not enter a park where children congregate during their time on parole. This ensures the worst offenders will not be entering parks and allows us to monitor and enforce this provision with GPS tracking. But inconsistent with the recent SOM Board recommendation, a statewide ban for all sex offenders, those not on parole, is going to be left to a future discussion that is likely to include attempts to address current residency restrictions. But our bill does provide protection and comfort for parents that those facing increased parole who are being actively monitored on GPS will not be allowed to enter parks where children congregate. Our bill seeks lifetime sentences for the worst offenders, but for those that we release, we have an obligation to have a system in place that seeks to best identify those most likely to reoffend, to provide the opportunity to best prioritize on them, and to seek to target treatment and reduce recidivism for all. Chelsea's law was introduced while the Sex Offender Management Board was conducting a full review of the incidents in San Diego, and thereby making broad recommendations on how to best reform our failed system. One of the centerpieces of the SOM Board was the need for a comprehensive containment model. This is simply an effective program that seeks to match the intensity of treatment to the offender's level of risk. It focuses on multi-agency collaboration, victim protection, intense community monitoring, specific treatment, supervision, and polygraph testing. This approach has been tried in limited fashion in Massachusetts, Oregon, Arizona, Virginia, and Colorado. In each case, it was demonstrated to reduce recidivism and protect victims. I'm not aware of any state that has implemented it statewide, so this change will put California on the forefront of this new technique. This provision